So I'm Mark Feather from Mark Feather Unredacted. I'm really glad that you're here. All right, so welcome. I'm excited today to have a special friend, former client, Jennifer McWilliams, and she's going to tell you a little bit about her story. Go ahead, Jennifer.
Hey everybody. So April 9th of 2023, there was an altercation. I did wind up getting arrested, me and my husband at the time.
Okay, she was placed in custody based upon the allegations contained in this. Actually, what they've alleged she did was she made her child, uncomfortable. Williams, Jennifer, removed the child by unnecessary force, causing the child discomfort. Okay, so let me tell you what happened. There was an argument. It turned into a little bit of physicality. Jennifer wants to protect her child. She goes to take the child, and according to a witness that you can read in this report, it caused the child some discomfort. There's no allegation of any injury. There was no injury. Jennifer would never do anything to hurt any of her children, and she wasn't in this case. In fact, to the contrary, she was protecting these children. You want to hear something crazy? I know you do. Stay tuned, and it's coming up.
Had some issues. We were fighting. It became physical. I had my daughter in my arms, and I was trying to protect myself and her. She was only 4 months old at the time. So we both wound up getting arrested for domestic battery and child abuse with no bodily harm. He was subsequently arrested in July.
All right, so what's coming up is, so subsequently, Jacob, the co-defendant, her former husband, was arrested for murder of another child. Now, does that make you think that she needed to protect her child from this guy to get her from him? I think so.
Once he was arrested in July for things that are not involved in this situation, they dismissed the case of us being separate defendants and put us as co-defendants. So that then tied anything that happened to my case to his case, and it became a whole situation from there. I was arrested in October. They tried to say that I had missed court, this, that, and the other. I then, right before I got arrested, I hired Mr. Mark because I seen that it was not going the way that it should be going.
Okay, I want to interrupt you for just a minute. So what we're going to do, we're going to put up some documents for you to see. We're going to show you that the case actually showed on the record as having been dismissed, that the case against Jennifer was dismissed. She called me and she said, I have to go to court. And I said, I'm looking at the case and it says it's dismissed. Anytime we are notified or have to do anything in relation to court, due process, which is fundamental to our system of justice, requires notice and an opportunity to be heard. So if you're not noticed of a court event properly, right, could be by subpoena, could be by summons, could be by arrest, could be by warrant, could be by a number of different things that can cause a writ of bodily attachment, can cause you to be brought before the court, but you have to receive notice, okay? Now, of course, you don't have to receive notice of a warrant before that warrant is issued. They can just come arrest you. But generally speaking, you can't be held in contempt for failing to appear in court if you've never been ordered to appear in court or signed something saying that you have to be there. In fact, in Florida, the law states that you have to have received notice that can be confirmed, all right? So when a judge checks the docket, checks the record, he is supposed to make sure that the person received actual notice of the court date before they're issued a failure to appear for capia. So I've appeared in court many, many, many times where the judges said, reset this and attempt notice again. Okay, so you have the right as a citizen of the United States, I believe, but certainly in Florida, to be notified before you can be held in contempt or a failure to appear for your arrest be issued. Well, as it turned out, Jennifer was never noticed of any court date. She was never given any official notice by the clerk of the court, by anybody other than her lawyer. And unfortunately, her lawyer apparently breached attorney-client privilege to say that she had told her that she was supposed to be in court, and that resulted in a warrant for your arrest.
Yes, sir.
Okay, pick it up from there.
So I was arrested at my home. I spent 41 days in jail. They held me on charges that were pretty much bull crap. So we fought. Mr. Mark fought tooth and nail for me to get me out of there. The only thing that got me out of there was them thinking that I knew something about a case that is unrelated to this involving my now ex-husband. They wanted to talk to me. Well, they kept me in jail for 41 days until I talked to them.
So let me interrupt you again. So what you don't know yet, and we'll show you this as well, is that we wanted a trial. The case was crap, as she said. It was. I knew that there was no way they could win based upon their own evidence that they had provided to us. So I immediately demanded a trial on your behalf. A motion for speedy trial, demanding a speedy trial. She had been charged more. Procedurally, it was right for a motion for speedy trial. So we filed a motion for speedy trial. In Florida, a motion for speedy trial, once that is filed, the court is obligated, shall conduct a hearing within 5 days and commence a trial within 15 days. Well, that didn't happen in this case. In fact, no hearing was ever held during the period of time, the 15-day, quote, recapture window that's provided under Florida law for the state to bring a prosecution. So they just totally ignored it. Well, that's illegal, and we know that that's illegal. So we file a motion for discharge. A motion for discharge is what follows a motion for speedy trial if no hearing is held. And so darned if we don't get a hearing on the motion for discharge, and there shouldn't even be one. It should just be dismissed, and the motion for discharge gets denied without a hearing, basically. So we may be able to incorporate those things in here as well. So my response was, your only choice is to go to the District Court of Appeal, which is the next higher court to the circuit court in the state of Florida. So we immediately file what's called a writ of prohibition, asking the District Court of Appeal to direct the trial court to relinquish the case or dismiss the case because it has to. Well, unfortunately, the District Court of Appeal concluded that it did not want to hear this case at this time. So that resulted in Jennifer remaining in custody, in my view, illegally on a case that she had not initially been charged or first appeared or even given notice on. Of a crime in the state of Florida and probably most other places in the United States, you have the right to a trial by a jury, with limited exceptions if you're charged with a crime. Okay? So we've just been trying to get that trial. We've been trying to get that trial. We've been demanding that trial. We've been asking the courts, how soon can we be heard? I just knew if we could get to that point. So she's... Okay, thank you so much once again for tuning in. We hope you enjoyed the beginning of Jennifer's story. We hope that you'll tune in for the next episode where we'll be telling the rest of that story. And in the meantime, if you will, please like, subscribe, and share. You also have been doing a wonderful job of sending me great comments. With regard to one of those comments, we had to ask about these feathers. Ask, have you been to the Philippines? And the answer is yes, we've been to the Philippines. Went on a mission trip earlier this year. It was fantastic. Maybe we'll be telling you about that in the future. But this feather came from one of George and Jeremy's fans, or Jeremy and George's fans over at What the Hales. They sent in a bunch of feather pens, and so I committed to wearing them during many of the recordings we'll be doing. But thank you once again, and we'll look forward to seeing you next time. So I thought that Seven should join us for just a minute. She wants to say bye to everybody too, and so we'll both look forward to seeing you next time.